Vamos a dar comienzo a la primera de las ponencias de la jornada de hoy, que lleva por título La responsabilidad parental y mediación relacionada con niños de padres separados, que corre a cargo de doña Haldi Coit, que es presidenta del Legislative Officer European Commission, la directora general. Hará la presentación Dani Mizko.
Buenos días a todos, kaixo egunon guztioi. Bienvenidos a la cuarta Semana Europea de la Mediación. Estamos hoy aquí para abordar la mediación desde el ámbito de la familia en Europa. Hoy tenemos con nosotros el placer de contar con la presencia de Haldi Coit como representante de la Comisión Europea y que pertenece a la Dirección General de Justicia y Consumidores, quien nos hablará sobre la responsabilidad parental y la mediación relacionada con los niños de padres separados. Gracias, Haldi, por estar con nosotros. Good morning, ladies and gentlemen, and welcome to the 4th European Mediation Week. We are here to address mediation from the family sphere in Europe. Today, we have Mrs. Haldi Coit, who is the representative of the European Commission and belongs to the Directorate General for Justice and Consumers, who will speak to us about parental responsibility and mediation related to children of separate parents. Thanks, Haldi, for being with us.
Thank you very much. Good morning to everyone. Sorry, I don't speak Spanish, so you'll have to bear with me in English, but I'll try to be short and not speak too fast. So the general basis of mediation in private international law is a directive from 2008 on mediation in civil and commercial matters. The objective of this directive is to facilitate access to alternative dispute resolution and to promote the amicable settlement of disputes by encouraging the use of mediation and by ensuring a balanced relationship between mediation and judicial proceedings. It applies in civil and commercial matters, including family law. The directive had to be transposed by member states by the 21st of May 2011, and the functioning of the directive was evaluated in 2016, and it found no need at that time to revise the directive, but that its application could be further improved through promotion and EU-funded projects. But there are also specific rules on mediation in EU family law instruments, the first of which is the Brussels II regulation from 2003. It became applicable on the 1st of March 2005, and on the 1st of August 2022, so this year, it will be replaced by a recast, which I will go more into detail a bit later. Similarly to the 1996 Hague Convention, Article 55.e obliges central authorities under this regulation to facilitate agreement between holders of parental responsibility through mediation or other means, and facilitate cross-border cooperation to this end. Recital 25 calls upon central authorities to cooperate both in general matters and in specific cases, including for purposes of promoting amicable resolution of family disputes in matters of parental responsibility. To that end, they should also cooperate with the European Judicial Network in civil and commercial matters, that I'll also get into a bit later. There is a possibility to transfer jurisdiction and limit the possibilities for spouses to prorogate jurisdiction. The possibility of transferring jurisdiction may also help if parents were to find an amicable solution and would want to have that specific agreement confirmed by a court in a member state that isn't the habitual residence of the child. Another instrument in family law which touches upon mediation is maintenance regulation from 2009. It became applicable on the 18th of June 2011, so a bit over 10 years ago. And its Article 51, paragraph 2.d obliges central authority obtaining voluntary payment of maintenance, where suitable by the use of mediation, conciliation, or similar processes. There is a possibility also in that specific instrument for choice of court in Article 4. However, it is not foreseen in cases of maintenance for children. Therefore, there is no transfer of jurisdiction in matters related to children foreseen. Brussels 2B or Brussels 2A recast regulation will become applicable from this August, and it will replace the Brussels 2A from 2003. The regulation is number 2019, number 1111, and it's Article 79.e, still similarly to the previous version, obliges central authorities to facilitate agreement between holders of parental responsibility through mediation or other means of alternative dispute resolution and facilitate cross-border cooperation to this end. But more importance should be given to Article 25, that calls upon courts deciding on parental child abduction cases as early as possible and at any stage of the proceedings, either directly or, where appropriate, with the assistance of central authorities, to invite the parties to consider whether they are willing to engage in mediation or other means of alternative dispute resolution, unless this is contrary to the best interests of the child, it is not appropriate in the particular case, or would unduly delay the proceedings. According to Recital 43, mediation might not always be appropriate, especially in cases of domestic violence. Additionally, there was a big change foreseen in Article 10 that made it possible to conclude choice of court agreements in more situations regarding parental responsibility, where the child has a substantial connection with that member state, in particular by virtue of the fact that at least one of the holders of parental responsibility is habitually resident in that member state is the former habitual residence of the child, or the child is a national of that member state. Furthermore, the parties, as well as any other holder of parental responsibility, have to have agreed freely upon the jurisdiction at the latest at the time when the court was seized, or they have expressly agreed to the jurisdiction in the course of the proceedings, and the court has ensured that all parties are informed of their right not to accept that jurisdiction. And the exercise of jurisdiction altogether is in the best interest of the child. So, as you see, there is a lot of conditions, but all of this is also linked to the fact that, according to Recital 22, it is also possible to use this choice of court in cases of child abduction, so parental child abduction, that even there it is for the purposes of giving the parents a possibility to come to a mediated agreement and to have that agreement confirmed by a court. It is possible to have an agreement on choice of jurisdiction. And of course, it is retained in a refined drafting that there is a transfer of jurisdiction to a court better placed to hear the case. I already touched upon the European Judicial Network in Civil and Commercial Matters. So for those who are not informed, the EJN, as it is shortly abbreviated, is a network of judges, representatives of ministries of justice and central authorities, together with representatives of legal practitioners who deal with private international law cases. The network usually meets about 6 times per year, and 2 of those meetings are family law matters, where family law matters are discussed. Members of the EJN discuss the practical operation of different regulations, including family law ones, and share best practices and experiences. The EJN also provides a lot of material to the public. The EJN has drafted many practice guides on the application of specific private international law instruments. There is the current one on the Brussels II regulation, but there is also work being carried out on a guide on the maintenance regulation and an update on the Brussels IIe guide to reflect the changes of the recast. But there are also fact sheets where member states can give overviews of their own national proceedings, and all of those fact sheets are available in all the EU member state languages. And in this remit, the EGN has also developed fact sheets on family mediation that can be found on the e-justice portal. So where all of the member states have given input on how their proceedings about family mediation are carried out. The network also recently started working on a future non-mandatory forum for the facilitation of amicable settlements under the maintenance regulation to assist central authorities fulfill the obligation foreseen for them. Additionally, there is a lot of work carried out by the Hague Conference on Private International Law that is responsible for the 1980 Child Abduction Convention, the 1996 Child Protection Convention, and the 2007 Maintenance Convention that all relate to children. And the Hague Conference is hoping to adopt the practitioner's tool for family agreements in the scope of all of these three conventions. The idea is that the practitioner's tool would help, as its name says, practitioners who are working in the field and who would like to have a family agreement confirmed. We are in the Commission coordinating the positions of the member states on this specific tool. The work on it was started in 2012, and it is hoped that the Council of General Affairs and Policy will be able to adopt the tool in its meeting in the beginning of March of this year. That is all from my side. This short overview of what we have in place and what is coming. And of course, if there are any questions, I'm available. But otherwise, I would wish you an enjoyable continuation of the event. Thank you.
Muchas gracias, Aldi, por realizarnos esta aportación desde la visión europea y enmarcarnos, ¿no?, en la visión europea de la mediación y, en especial, pues todo lo referente a su uso en el ámbito de la familia. Comentaros que la ponencia de Aldi estará disponible en YouTube y estará traducida por aquellos que tenemos más dificultad con el inglés, como es mi caso, por ejemplo.
Thank you, Aldi, for your conference, and we continue with the event. Thank you.